Good evening, ladies and gentlemen, and welcome to this edition of Illinois Law, a public service brought to you by the Illinois State Bar Association. I'm Judge Cheryl Cesario, your host this evening, as we discuss the topic of marriage and family issues as they relate to lesbian, gay, bisexual, transgender, and intersex persons. My guests this evening are attorneys Jennifer Shaw, Richard Wilson, and Rachel Toft. While licensed to practice law in Illinois in 1996, Attorney Shaw has been a solo practitioner since 2003, concentrating her practice in domestic relations issues with a special emphasis on crafting solutions for unmarried couples. She is a past chair of both the ISBA Sexual Orientation and Gender Identity Committee and the Committee on Minority and Women Participation. Attorney Wilson has been practicing law since 1992. He currently is a partner at the law firm of Grum and Levitt, P.C., focusing on family law with a particular emphasis on non-traditional family law, including the rights and interests of persons in same-sex relationships. He is a member of the ISBA Standing Committee on Sexual Orientation and Gender. After graduating in 2004 from law school, Attorney Toft has been a sole practitioner and the owner of the law offices of Rachel Toft since 2007. She concentrates in adoption and family law and handles same-sex adoptions in addition to a wide variety of domestic relation cases. She has been recognized as a 2010 Rising Star in Family Law by the Illinois Super Lawyers. So let's start to discuss the topic we hear so much about, gay marriage. Can two people of the same sex actually marry in Illinois, Richard?
No.
Do they have any options if they can't marry in Illinois? Can they go to another state and marry? Say Ohio? Oh no, say Iowa.
Iowa, not Ohio. They can go to Iowa. Although Illinois law will not allow them to go to another state and obtain a marriage that they can't legally obtain here. So they can do it, but Illinois won't recognize it.
Can you be prosecuted if you go to another state that allows you to be married and then come back here to live?
Sure. It hasn't happened, but there is a civil sanction, not a criminal sanction, for violation of the law. That law only applies to Illinois residents. It says they cannot go somewhere else. Although other...
And marry. They cannot go somewhere else and marry.
Right. And although persons from other jurisdictions could move here who could have legally married in another jurisdiction and then move to Illinois.
Now, that's same-sex couples, because heterosexuals can go to Las Vegas and get married or go to the Caribbean and get married, or and Illinois recognizes their law.
Right.
All right. What are the states that actually a gay person could go and get married in?
Currently Massachusetts, Connecticut, New Hampshire, Vermont, Iowa, and the District of Columbia.
It's interesting that you mention Massachusetts. If I go to Massachusetts and get legally married there, can I move back to Illinois with my partner and have that relationship recognized?
No.
Okay. And if my relationship dissolves, can I get a divorce in Illinois?
No.
Well, can I get a divorce in any state if I went to a state that legally married me? Is there any place I can get a divorce?
If you satisfy the residency requirements for divorce in the particular state, they vary from state to state. Illinois, for example, is 90 days prior to the judgment if, of course, it's a legally recognized marriage.
You must reside in Illinois for 90 days.
But typically, that's fairly progressive. Typically, most states, it's about a year. Some states it's longer. But you have to have lived in the state for a particular period of time. The theory being that because the state's divorcing you, it's going to adjudicate your property rights to your children, your rights and interests that arise out of the marriage, the duty to support each other, and all those things the state doesn't have an interest in if the persons aren't actually resident of the state, typically.
Well, how long do I have to live in Illinois if I am marrying a heterosexual partner to get married? Is there any requirement?
I think you just have to get the license, and I don't think there's a waiting period for the license.
I don't believe so.
I don't think there's a waiting period.
All right. Rachel, if I want to stay in Illinois and reside in a committed relationship with a partner, how, if at all, can I duplicate the benefits of marriage?
Well, you can't completely duplicate the benefits of marriage, but there's various things you can do. You can do domestic partnership agreements to try to lay out rights and responsibilities in terms of your relationship. Some areas, particularly Cook County, have domestic partnership acts where you could register your domestic partnership. That doesn't necessarily confer any legal rights, but it confers a status, a domestic partnership status. That status then you could take perhaps to your employer and be recognized for health benefits, for example, is what people use that for. There's a lot of other things you can do as far as planning too. There's, estate planning, powers of attorneys for healthcare, power of attorney for property, name your partner in your will, create trusts. There's a variety of tools, but you have to use a lot of tools in the toolbox to try to duplicate what you can get with just simply applying for a marriage license in a heterosexual couple.
Other than the domestic partner registration that you mentioned, all the other legal remedies, those are available to everyone, are they not?
Yes, they'd be available to everyone. However, if you heterosexual couples could just go and apply for a marriage license, and in getting married, a lot goes along with that marriage license. A lot of those, the default for the laws, your spouse, if you're hospitalized, your spouse is your next of kin for making decisions. However, if you're a same-sex partner, if you're hospitalized, your partner isn't necessarily the one without the power of attorney for health care, isn't the one to make decisions. The law is going to look to your next of kin, which is going to be potentially, your parent.
And what about if you die without a will? Will your property, your personal and real property, automatically go to your domestic partner under Illinois law?
It would not go to your domestic partner. If you do not have a will, it's going to go according to, the intestate laws. It's going to go to your parents or your siblings, your children if you have them, according to that distribution. So if you don't have a will, it's not going to your domestic partner.
Let me turn to you now, Jennifer. Let's talk a little bit about these powers of attorney.
Sure.
You hear of this language thrown around quite a bit. That people understand wills generally, and people may understand the concept of a trust, but this power of attorney, and then I hear, oh, it's health care, oh, it's property. Sort that out for us, please.
Absolutely. The Illinois legislature has codified or put into statute forms for healthcare powers of attorney and property powers of attorney. And basically what this is your ability to dictate your wishes as to what happens to you and who makes those decisions if you're unable to make those decisions with respect to your health and your property. You have the opportunity, if you draft or have a power of attorney drafted for you, particularly with health care, to make the determinations as to what happens to you in end-of-life decisions or medical decisions that need to be made if you are not able to make them. So if you are critically ill and you can't make that determination, your power of attorney, the person who you indicate as your agent, would make those decisions for you. And so same-sex couples particularly have a real need to make sure that their wishes are codified in a piece of paper. I think it's pretty clear in the LGBT community that sometimes the relationships aren't accepted, and what we have seen happen time and time again is the people, as Rachel indicated, the people who would normally have that responsibility without a healthcare power of attorney don't recognize the relationship that the individuals are in, and then try to take over making decisions that someone would prefer their partner to make. So seeing a lawyer is always a good opportunity to talk about what you can and can't do.
And let me ask you this. So,
sure.
From a practical standpoint, you're in an automobile accident,
Sure.
God forbid, and you're on life support, and you don't have a power of attorney for health care, and your parents are still living, and you have a partner, and maybe you've lived with this partner for 20 years. Who gets to make the decision as to whether a do not resuscitate will be put in place, for instance?
Under Illinois law, if you do not have a healthcare power of attorney or an advanced healthcare directive indicating that you would like your partner to be the one to make that decision, it would be your parents who would make that choice.
And let's switch over to the power of attorney then for property.
Sure.
What's the difference between those two, and how does that work?
Healthcare powers of attorney deal with those decisions that need to be made regarding your healthcare decisions and potentially your end-of-life decisions. property powers of attorney deal with the disposition of your property. So if you're in the hospital and you're unable to pay your bills because you are away from your checking account, your agent can do that for you. If you are unable to make certain transactions because of an inability to do so, your agent can make those decisions for you. And that is something that has to be indicated in your power of attorney. If you don't have one, your partner cannot make those decisions for you.
Now you say that Illinois law has certain forms. Can people go online, pull down these forms and fill them out? Is that how you do it?
You can do that, but I always suggest that you see an attorney to make those decisions. I think a lot of people several years ago became very aware of the presence of healthcare powers of attorney with Terry Schiavo. That was a situation in which parents and a spouse were battling over what to do with that woman and her healthcare decisions and her end-of-life decisions. So making sure you can do it online and you can craft it yourself, but attorneys sometimes have more insight as to the language that needs to go in there to make sure that your specific wishes are met. In addition, part of the healthcare power of attorney and the short-term property power of attorney statutes allow you to designate who you wish your guardian to be in case of your
total disability.
Total disability. And you have then spoken. It's not a question of a judge determining what your wishes are. You have said in a very real legal document, I want my partner to be the one who is my guardian if it comes to that point in life.
Now, but these powers of attorney, they're not just for gay people.
No.
These are standard traditional legal kinds of contracts that we use.
Absolutely. They're for everyone. And they're a part of a good estate plan.
All right, on that note, we're going to take a short break, and then we'll return to this edition of Illinois Law.